Hi guys, this is Nick Sally with nicksally.com. Life and legal tips for creative entrepreneurs, the home of holistic hustle, and a friendly reminder to take care of you, then take care of business. Today I'm going to be talking about a life tip, so I do need to give, a legal tip actually today, and I do need to give a bit of a disclaimer at the beginning, another little friendly reminder. So anything I say in this video is for informational and educational purposes only. It's not legal advice and it does not create an attorney-client privilege between us. Now, having said that, if you do have specific legal questions, then I would encourage you to consult with a licensed attorney in your jurisdiction or state. That way you can get tailored guidance for your specific question. All right, so let's get on to the legal tip for today. Today I want to talk a little bit about copyright law and trademark law and hopefully clear up some confusion, because I hear entrepreneurs kind of using them interchangeably and in ways to where maybe they're confusing one with the other. So the desired outcome for today is for you to walk away with a better understanding of the definitions of copyright and trademark law, a better understanding of what each of them protects, and then also knowing what they don't protect. So before we even talk about them specifically, let's just kind of talk about vocabulary. Often I will hear entrepreneurs say something like, I want to copyright my book, or I want to trademark this or that, this t-shirt, that kind of thing. They're using the phrase or the word as an actual verb, and really it's a noun. So what they're probably meaning is that they want to secure some kind of federal registration for their copyright or their trademark that shows these exclusive rights they have as the intellectual property owner. So copyright and trademark as types of intellectual property do have their own definitions, and I want to get into copyright first. So when we talk about copyright, the actual definition, like from the statute, paraphrased, is an original work of authorship fixed in a tangible medium for more than a transitory period of time. What in the world does that mean? Okay, in plain English, the way I think of that is that copyright is an exclusive right, and it protects original works of authorship that include literary and different types of artworks. So what does that protect? Books, movies, video games, drawings, paintings, choreography, architecture, code, and a couple of other things as well. And so when you think about copyright, just think, is it an original and creative work of art or literary work? And is it recorded? If it is, then it's already protected under copyright law as soon as it's recorded or written down. You don't have to necessarily get a federal registration for it. The reason that a federal copyright certificate or registration is important is in the case of litigation. So if you find that, you find yourself in a situation where you believe someone has infringed your copyright, they're unlawfully copying something or selling something, then if you want to file a lawsuit, it's a lot easier from an evidence standpoint to be able to point to an official piece of paper that has, you as the copyright owner, the date of the certificate and things like that. Otherwise, when people go to court, it's kind of a he said, she said situation as far as who's the actual rights owner or author or creator of the work. Now, copyright does not protect, words that are like just a single word or short phrases, and that's for public policy reasons. So, for example, the words or the phrase, I love you. It's been used in hundreds or thousands or maybe even millions of songs by this point. And it would be really unfair if the government gave someone the exclusive rights over just those 3 words and no one else could use them for any reason whatsoever. So copyright doesn't protect just a single word or short names, names or phrases. However, that could be protected under trademark, and we'll dig into that a little later. So as a recap, think of copyright as a noun, not necessarily a verb, and just think of it as an exclusive right that protects literary works or artworks that are sufficiently creative and have been recorded in some way. So now let's move on to trademark, which is actually my favorite area of intellectual property law. When we think of trademark, the definition that I want you to keep in mind is, and the definition from the statute is really long, so I'm just going to give you the plain English version here. When I think of a trademark, I think of it as basically a word, a phrase, a logo, or a combination of those things that distinguishes one company's goods and services from another company's goods and services so that customers can make an informed purchasing decision. So a trademark is basically like this little package of information. So if you see Toyota versus Bentley, you immediately know what's the quality of the product, what's the price point, what kind of service you can expect when you walk into the dealership. It's just boom, boom, boom. All of that information is immediately conveyed to you right when you see the trademark. So logos, I think, is the area where people might not know this, but logos can be protected under copyright and trademark law. And that's because a logo could be considered to be an original and creative work of art. And then to the extent that it identifies a business and helps customers distinguish between goods or services when they're in the marketplace and they're buying, then it also serves as a trademark and would be eligible for trademark protection. So I think that's one area where it's a thing that's protected under both areas of law. Here's one thing where I do see people get confused, and I've mentioned it just previously, which is that short phrase. So a lot of times people will say, I'm going to copyright this, that, or the other, and it's like they spit out something. I'm going to copyright by Felicia. And it's kind of a thing of, you can't copyright that because it's not eligible for copyright, but you might be able to trademark it if now for by Felicia, I don't know if it does or not, but if you think of the movie Friday, maybe it could serve as basically distinguishing the goods and services of entertainment in the form of a theatrical movie or something like that. But I will tell you probably the most famous phrase or slogan or catchphrase is the "Let's get ready to rumble." What comes to mind when I say that? You probably immediately know what I'm talking about, what it references, and things like that. So when you hear "Let's get ready to rumble," it's immediately evident that the goods and services that are connected to it are boxing matches or sporting goods. And you can probably even see the ring in your mind and the guy standing in the middle of the ring announcing the fighters and things like that. That catchphrase has become so connected and well known that it serves as a trademark, as an identifier of that particular good or service. So it's like you hear "Let's get ready to rumble," you know that's a boxing match or some kind of more aggressive sporting event. We're not talking about tennis or golf. So that was my legal tip for the day. I hope now that you have a better understanding of the differences between copyright and trademark law, the definitions, what is protected under each, and what's not protected. And now you know that you can use it as a noun versus a verb. And so hopefully that cleared up a little bit of confusion. If you found that helpful, please share it with your friends that you think would benefit from that. Now it's your turn. If you have some kind of a tip about business or something that you've done in the past that was really helpful for you, or if you have gone through the process of filing a copyright application and you received the certificate, or you went through the process of filing a copyright or a trademark application or something like that, and you just want to talk about that experience, or how proud you were to get that in the mail from the government, then by all means feel free to comment with that. I'm sure we can all learn from each other. if you want more helpful tips, be sure to, one, subscribe to my YouTube channel, but also subscribe to niksally.com for, really helpful resources in your inbox. So that's niksally.com. And you can stay connected in my Facebook group as well. Just go over to Facebook and look for Nick's Creative Community, Nick's Creative Entrepreneur Community, and yeah, there's some really good stuff going on there. And if you want support and inspiration from other fellow entrepreneurs, that's a great place to be. So yeah, again, thanks for watching so much. This is Nick Sally with niksally.com, life and legal tips for creative entrepreneurs, the home of holistic hustle, and a friendly reminder to take care of you and then take care of business. I'll see you in the next video. Bye-bye.